responsable sa pagpili, magkaisa at magtulungan.
Kakayahan mo.
Maayong hapon, Mayor Duterte. Maayong hapon sa tanan. I'm not a good speaker like Harry or Vic, but I'll try my best to share with you whatever I know about our topic this afternoon, which I hope can be very helpful to you also. I welcome the recent public attention given to the issue of people's initiative, since it necessarily brings to fore the very document which provides for this process, the process of effecting constitutional change. I'm talking about the 1987 Constitution, which is our fundamental law. Allow me to start with some short storytelling about our experiences on the matter of constitutional governance. Let's go back to the experience of our national heroes who fought, and some of them even died, to free our people, our land, from foreign domination. They knew that once we become a free people of a free land, we need a way to govern our new nation. We need a way to govern our relations with one another, as well as our relations with other nations and the peoples of other nations. In the struggle of our national heroes to establish a society under the rule of law, they must have asked themselves some basic questions of governance under a system of laws. They must have asked themselves the question, since we need laws, because without laws there can be no harmony in society, there can be no order, and for that development, the question is, if we need laws, who will make the laws? They also have to ask, then, if there are laws, who will enforce the laws? And if there are some doubts as to the meaning of the laws, who will now explain the meaning of these laws? In other words, they are asking the questions, the basic questions which we know are the basic questions of governance. Now, in grappling for an answer for these questions, our heroes must have understood the wisdom why in other societies people decided to have a basic law or a fundamental law, a law which will serve as the standard to which the validity of all laws shall be tested. Now we understand that this must be the reason why other societies had to adopt a basic law and then fundamental law to govern themselves. In other words, our heroes have realized that we must have a fundamental law. We must have our own social contract. We must have our own agreement on how we shall govern ourselves as a people and how our individual rights shall be recognized, promoted, and protected. Thus, as early as 1897, the Filipino revolutionaries fighting against the forces of colonial Spain established the Biak na Bato Republic, which was inaugurated under the Biak na Bato Constitution. In other words, as early as that period, we have already realized the need to adopt a constitution to govern ourselves in the event we can really be totally free from foreign domination. Then, with the Declaration of Independence on June 12, 1898, the first Philippine Republic under the presidency of Emilio Aguinaldo was established under the newly promulgated Malolos Constitution. Again, there is the continuing recognition that there must be a constitution to govern us as a people in a free land. In fact, the Malolos Constitution is recognized as the first democratic constitution ever to be promulgated in the whole of Asia. But then, the first republic of the Philippines was to be short-lived. For even as the Philippine state was being established, the United States was already planting the seeds of another sovereignty over our country. That's why Atty. Roque is not happy about, about the Americans for what they did to us. Then under the Treaty of Paris of 1898 between Spain and United States, sovereignty over the Philippines was transferred from Spain to the United States, again by virtue of the Treaty of Paris, which actually, as Attorney Harry said, is a contract of sale. It provides for the ceding of the Philippine Islands by Spain to the Americans for the price of $20 million. That Treaty of Paris historically marked the end of the Malolos Constitution and the start of the American regime in the Philippine Islands. A regime where the Philippine Islands and the Filipino people were governed by American laws. Well, as history has shown us, later on, the Americans decided to give up their only colony in Southeast Asia. However, in preparation for its eventual withdrawal, the United States allowed the natives of the Philippine Islands to promulgate and adopt a new constitution to govern the Philippine Islands during the time when the Americans ruled over us. And that constitution is nothing but the 1935 Constitution, which provided for also for a Commonwealth government which will serve as a temporary or transitory government in the event later on the Americans will decide to withdraw sovereignty over the Philippines and thus begin the establishment of the government of the Republic of the Philippines. Of course, the adoption of the 1935 Constitution, its full effectivity was interrupted by the Japanese invasion and occupation of the Philippine Islands. In fact, during the Japanese occupation, the Japanese saw to it that there will also be a Philippine Constitution to be adopted and promulgated to govern the Philippine Islands during the Japanese occupation time. Now, this again is a continuing recognition of the importance of a constitution to govern a society. Then finally, at the end of World War II, the United States formally withdrew its sovereignty over the Philippines on July 4, 1946. This is the date which is actually, legally speaking, the establishment of the Philippine state, the Republic of the Philippines. Because it was only at this time that the four elements of statehood was completed with the withdrawal of sovereignty of the United States over the Philippine Islands. And precisely because of this, the 1935 Constitution was declared to continue to be and to be used this time as the Constitution of the Republic of the Philippines. So the 1935 Constitution is the first Constitution that we had as an independent republic. Now, that is not over. The story of our constitutional experience is not over. Because 15 years after the inauguration of the Philippines as an independent republic, the country experienced major economic and political crisis, then perceived to be serious enough to undermine the stability of the country. The problem of poverty, characterized by the widening gap between the rich and the poor, aggravated by a high population growth rate, worsened as the economy failed to take off, operating along the growth path taken by the government. Efforts exerted in identifying the obstacles and causes of Philippine underdevelopment eventually included the 1935 Constitution as the obstacle itself. It was criticized as a colonial document which was adopted by an enslaved people as it was promulgated in 1935 when the Philippines was still a colony of the United States. As an independent republic, confronted by the growing clamor for a new constitution, the Philippine Congress then responded by calling for a constitutional convention to propose amendments to the 1935 Constitution. The elections were held, and the delegates to the convention were elected on November 10, 1970. And the convention convened on June 1, 1971. While the convention was in session on September 21, 1972, then President Ferdinand E. Marcos Sr. issued Proclamation 1081, placing the entire Philippines under martial law. This martial law proclamation compelled the Philippine Constitutional Convention to suspend the sessions. Nonetheless, 4 months after martial law declaration, the Constitutional Convention finally approved the draft of the new Constitution, which was thereafter submitted to, or will be submitted to, for approval in a ratification. For that purpose, President Marcos issued Presidential Decree number 73, setting the plebiscite for ratification on January 15, 1973. But this did not materialize. What happened later on was that President Marcos decided to indefinitely postpone the conduct of the plebiscite after the political opposition, mainly from the Liberal Party, raised various constitutional issues before the Supreme Court. They were questioning the constitutionality of President Marcos' exercise of legislative power because under the 1935 Constitution, legislative power is vested with Congress, and during that time, there was still Congress. While the cases were still pending before the Supreme Court, the cases questioning the constitutionality of the issuance of the decree and the setting of the plebiscite, while the case was still pending, President Marcos issued Presidential Decree number 86, organizing the Citizens' Assembly purportedly for the conduct of democratic consultations on certain public interest issues. Later, the political opposition learned that among the questions being asked during the Citizens' Assembly session are the questions, do you approve of the proposed constitution? Because of this, the oppositionists were alarmed, because this is not the way to ratify the 1973 proposed constitution under the 1935. In the 1935, the procedure is clear. The proposed new constitution must be plebiscite, must be ratified by the people, and the plebiscite called for that purpose, and to be participated in by registered voters under the administration of the COMELEC. But here is the case where the alleged ratification is done in the citizens' assemblies. And it is not done by secret balloting. It is done by viva voce. I don't know, maybe some of you participated in the citizens' assemblies. But this was not the constitutional way of ratifying the Constitution. And that issue was raised by the oppositionists before the Supreme Court. While the case questioning the constitutionality of the Citizens' Assembly session was going on, the oppositionists learned, again, this was confirmed, that the question that is very controversial being asked of the people in the Citizens' Assembly is that, do you approve of the new Constitution? In violation of the 1935 rules on ratification. Now, this development alarmed the opposition, who immediately filed a petition before the Supreme Court, asking that the cases questioning the constitutionality of the scheduling of the plebiscite, that the cases they raised before the Supreme Court must be resolved the soonest time possible because of the goings on in the citizens' assemblies. They were arguing that because in the citizens' assemblies, the people were already asked the question, do you approve of the new constitution? They were afraid that the events might overtake their petition. Now, this was actually during December already. That's why the Supreme Court scheduled the session for the hearing or the hearing of the petition on January 17, 1973. This was a very dramatic session because while they were the best legal minds of the country during the time, representing both parties, government and the opposition, while they were arguing often heatedly, this Chief Justice said, I will have to suspend and we go to on recess, suspend the session for a while. Why? Because according to the Chief Justice, an emissary sent by President Marcos is in my chamber, and he wants to talk with me. So I had to see him, and I want to know why he was sent by President Marcos. So the session was suspended for a while. The Chief Justice went to his chamber, and the emissary was there. What did the emissary do? The emissary said, Mr. Chief Justice, I was sent here to give you a copy of a newly issued proclamation. And what is that proclamation? That was Proclamation 1102. What does it say? It declares that in the citizens' assemblies, when the people were asked, do you approve of the proposed constitution? They overwhelmingly approve of the new constitution. That was the content of Proclamation 1102, dated January 17, 1973. So the Chief Justice went back to the session hall and told everybody, guys, we have to suspend the proceedings because of this document. To make the story short, the Supreme Court had to decide to dismiss the petition because the issue had become moot and academic. Because the issue in the petition is they don't want the plebiscite to be scheduled because it is contrary to the 1935 Constitution. But here is a situation where you already have a Proclamation 1102 which says that the new Constitution has already been approved in the citizens' assemblies by those who participate there, which in fact included 15 years old and above. Anyway, this resulted, of course, resulted to the dismissal of the petition questioning the scheduling of the plebiscite. Because there is now a proclamation saying there is now a new constitution. So what did the opposition do? They did not give up. They again filed cases before the Supreme Court, questioning this time the constitutionality of Proclamation 1102. The Proclamation 1102 is null and void because the declaration that there was a ratification is not a valid declaration because the procedure followed was in violation of the fundamental law. Now, they filed this petition. I don't have to go to these cases, but I just have to inform you that they filed this petition questioning the constitutionality of 1102. But the petition was again dismissed by the Supreme Court. Remember, the question is, 1102 is not constitutional because it violated the rules on ratification under the 1935 Constitution. So the issue of constitutionality was brought before the Supreme Court. And under the 1935 Constitution, the Supreme Court can only declare a law, a decree, or a proclamation unconstitutional upon a vote of 2/3 of all the just members of the Supreme Court. Under the 1935 Constitution, our Supreme Court is made up of 11 justices. 11. 6, in effect, 6 of the justices, 6 out of 11 said there was no valid ratification because the ratification was violative of the procedure in the rules under the 1935. 6 said there was no valid ratification. 6 out of 11. But the constitutional rule is to declare unconstitutionality, the required number of votes is a qualified majority. Qualified majority of what? 2/3 of all the justices. There are 11 justices, and 2/3 is 8. Therefore, despite the fact that the majority of 6 said that 73 Constitution was not validly ratified, the Supreme Court has no choice but to eventually declare that the new Constitution is in force and effect. Precisely because they were not able to reach the qualified majority of 8 votes. Only 6. They only got a simple majority, not the qualified majority of 8. Thus, the 73 Constitution was declared in force and in effect. If you read that case, doon sa dispositive portion, the Supreme Court never said that the 73 Constitution was validly ratified. Precisely because it was not. But, since the court cannot declare Proclamation 1102, which says that the new Constitution had already been approved and ratified, then the Supreme Court had no choice and declare there is no more legal obstacle for this new Constitution to take effect. That is why we had the 1973 Constitution, and that was the story of its ratification. Yung sinasabi nga ni Mayor Duterte na parang may template na inuulit, parang naglulukuhan na naman tayo ulit ngayon. No? But anyway, later, additional amendments were introduced. Additional amendments were introduced. I will not go to the details. But the most controversial amendment which was added was this controversial Amendment number 6. And what is that? Amendment number 6 says that even after the lifting of martial law, the President shall continue exercising lawmaking powers. Dati ang power ng President dahil martial law administrator siya. So if you lift martial law, no more power, extraordinary power of lawmaking. But with Amendment number 6, it says, even after the lifting, the exercise of the power shall continue. Okay? That's Amendment number 6. That is why our justices were saying the 1973 Constitution is a constitution which could be considered a constitution of could be called authoritarian constitution. It is a constitution which institutionalized dictatorship in the constitution itself. So before authoritarian power came from martial law administrator, but now no more. It's now a constitutional provision. Why? Because of the passage of Amendment number 6. Incidentally, that amendment was introduced, I think, months before the arrival of the Pope. The Pope was scheduled to visit the Philippines. So I think it would not look good if we continue to be under martial law. So Marcos lifted martial law, but Amendment number 6 came in, which is even worse than martial law. But anyway, the effectivity in enforcement of the 1973 Constitution ended on February 25, 1986, when President Corazon Aquino issued Proclamation number 1, establishing a revolutionary government after the February 22 to 25 EDSA revolt ousted President Marcos from power. This was Proclamation number 1, establishing a revolutionary government. The new government of Aquino declared itself as a revolutionary in origin, democratic in essence, and transitory in character. It premised its legitimacy on the republicanism principle that sovereignty resides in the people and all government authority emanates from them. In fact, in Proclamation number 1, President Corazon Aquino declared that she is taking power in the name and by the will of the Filipino people, not by virtue of the existing constitution, neither by virtue of any existing law, but this is an extra-constitutional assumption of power under the Republican principle that sovereignty resides in the people and all government authority emanates from them. That is expressly provided for in the proclamations of Corazon Aquino in the establishment of the revolutionary government. On March 26, 1986, after a month of ruling as head of the revolutionary government, President Cory Aquino issued Proclamation number 3, wherein she declared, among others, that in response to the people's demand for transition to a government under a new constitution in the shortest time possible, and in order to guarantee basic human rights and fundamental freedoms during the period of transition, the revolutionary government adopted the 1973 Constitution, but removing the authoritarian provisions. And that became the transitional constitution or the provisional constitution, which was eventually called the Freedom Constitution. Thus, from February 25 to March 24, that's roughly 1 month, the Philippine Republic was governed by a revolutionary government without any formal fundamental law, without any constitution. In effect, during that 1 month period, the revolutionary government itself was the constitution. Whatever it says is constitutional, because there was no constitution which will serve as a fundamental criteria in determining whether or not the act of government is valid. Only a constitutional criteria can do that. Remove the constitution, anything goes. Power rules. And that happened during the revolutionary period under Corazon Aquino. That's when we have to realize the importance of a fundamental law. Then on April 23, President Aquino issued Proclamation number 9, creating the Constitutional Commission, which convened on June 2, 1986, to begin its mandate of drafting the new Philippine Constitution. The Constitutional Commission completed its task on October 15, 1986, and the proposed new Constitution was ratified by the people. You ratified it on February 2, 1987. Thus, February 2, 1987 is the date of effectivity of the new Constitution, which until now governed us as the Philippine Republic. Now let me sum up what I earlier presented. Number 1, that the Philippine Constitution is our social contract as a people. Ito ay ang ating panlipunang kontrata. This is our agreement as a people. This is our agreement on how our country will be governed and how our rights will be recognized and protected, even from that government which was established to protect our rights. Number 2, as a people, we adopted the Constitution which enshrines the principles and the rules to govern us as we strive to build a just and humane society with the aid of a government that we shall establish, which should embody our ideals and our aspirations, a government which shall promote the common good, a government that shall conserve our patrimony, and the government that shall secure to ourselves and our posterity the blessings of independence and democracy under the rule of law. Now, these principles you can readily see in the 1987 Constitution preamble. In the preamble, you can readily read that the author of the 1987 Constitution are the sovereign Filipino people. And why did we decide to group together as a society? What is it? What is our aim? Because we want to build a just and humane society. But in order to build that, we need to establish a government. But that government is there, among others, to secure to ourselves and our posterity the blessings of independence and democracy under the rule of law. Now, number 3, that the author of the Constitution, that us, the author of the Constitution, we are the only ones who can change the provisions of the document. Because this is our social contract. We are the parties to the contract. Therefore, we are the only ones who can introduce changes to this contract. Nobody else. Changes can only take effect with our approval. Precisely because of that, the people included in the Constitution, the rules and principles and processes that govern and regulate changes in the fundamental law. So this is where we go now to the short mention of the process of constitutional change under the 1987 Constitution. We can find it in Article 17 of the new Constitution. The Constitution provides, and this is the rule enshrined by the people in our social contract. The people said, this Constitution will be changed either by amendment or by revision. And how do you distinguish amendment from revision? Well, the Supreme Court tried to help us by pronouncing in a number of cases that amendment is distinguished from revision. When you talk about revision, you refer to changes that alters the basic principle in the Constitution. Such as if you change from presidential to parliamentary, you are changing the principles of governance. That is revision. Well, amendment is merely a change of certain provisions without affecting the basic principles of governance. Now, under the 87 Constitution, the process of constitutional change involves 2 steps. The first step is the proposal step. First, there must be a proposal. Proposal of what? Propose amendments or revision, as the case may be. And the second step is the ratification step, whereby the proposal will be brought to the people in a plebiscite for their approval or rejection. That's the rule set forth in the Constitution. Who placed it there? The authors of the Constitution. We, since we are the authors of the Constitution. Now, this authority to propose constitutional change is delegated by the people to the following. The following are the delegates who can exercise proposal, the power to propose constitutional change. Who are they? Number 1, Congress, acting as a constituent assembly. There is a distinction between legislative power, or the power to make laws, and constituent power, which is the power to propose constitutional amendments or revision. Congress can propose constitutional changes because under the Constitution, Congress has the delegated power called constituent power, which is the power to propose changes. Who else? Aside from Congress, changes can also be introduced or proposed by a constitutional convention. Are these the only two ways where proposal can be made as far as constitutional changes are concerned? No. There is the third one, which was introduced in the 87, in recognition of the fact that sovereignty resides in the people, in all government authority emanates from them, and the fact that this is the document of the people. So the people should be given the chance to directly propose changes. That is where the introduction of people's initiative came in. Now, these are the three mechanisms in the Constitution through which proposals can be made. Okay? Now, what are the rules of this? Under the Constitution, Article 17, Section 1, any amendment to or revision of the Constitution may be proposed, number one, by Congress as a constituent assembly after 3/4 of all its members shall vote in favor of the convening of Congress as a constituent assembly for the purpose of proposing constitutional amendment or even revision. The second is that Congress, by 2/3 votes of all its members, can call for a constitutional convention to propose constitutional amendment or revision. And the third rule is that Congress may, by majority vote of all its members, submit to the electorate the question of calling such convention. Now, amendments to this Constitution may also be directly proposed by the people through initiative. Remember, a change in the form of amendment is the only change process that is allowed to or given to the people in the form of people's initiative. Revision is not allowed by the Constitution as far as people's initiative is concerned. Now, what is the rule on people's initiative? A petition of at least 12% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters therein. Now, this is important. This is a constitutional provision. Congress is mandated by the Constitution to enact a law for the implementation of the right to people's initiative. That is a constitutional mandate, a constitutional directive addressed to what? To the Congress. That in order to exercise this right of proposing amendment to the Constitution through people's initiative, Congress must first enact a law implementing people's initiative. That is a constitutional rule. Well, in compliance with the constitutional mandate, Congress passed the enabling law on August 4, 1989. This is the Republic Act 6735, the law on initiative on local ordinances, initiative on national statutes, and initiative on the Constitution. That's RA 6735. So by enacting that, Congress was able to fulfill and comply with the constitutional mandate of passing an enabling law to put into effect the right to propose amendment through people initiative. Now, this is where everything becomes controversial. In the case of Santiago versus Comelec, the Supreme Court, promulgated by the Supreme Court on March 19, 1997, the Supreme Court ruled that the Republic Act 6735, enacted by Congress in compliance with the constitutional directive in order to implement the law on people's initiative, according to the Supreme Court, RA 6735 is incomplete, is inadequate, is wanting in essential terms and conditions insofar as initiative on the amendments to the Constitution is concerned. That the law is incomplete, inadequate, and wanting. In fact, until now, to date, Congress has failed its constitutional mandate of legislating the law on initiative. In effect, to date, there is still no law implementing the rule on people initiative. Therefore, it is not in effect. It is not in effect as of date. Now, in sum, the present issue on the move to amend the Constitution by way of people's initiative is patently premature in the absence of the constitutionally mandated enabling law. Likewise, without legal basis is the Comelec resolution pertaining to the process and procedure in the implementation of RA 6735. For how can a Comelec implement a law which does not exist? What is being proposed in this by subgroups as a possible amendment is the inclusion in the phrase of Congress, all members of Congress shall vote. Because that phrase is ambiguous. It doesn't explain whether Congress, in deciding to convene as a constituent assembly, will vote jointly or separately. Definitely jointly will be in favor of the House of Representatives, which is being opposed by the House of Senate. Now, you see, I've also heard stories about this. When the CONCOM was working on the new draft of the 87 Constitution, initially the choice is to establish a parliamentary government. In other words, unicameral legislative assembly. Unicameral. But on the eve, according to that story, when they were discussing this, the presidential, the parliamentary won only by one vote. Only by one vote. So on the next day, when the actual vote was taken by the committee, which was responsible in drafting that provision of the Constitution, one of the commissioners changed her mind. There was a change of decision by one commissioner. The change was, instead of voting for parliamentary, he voted for presidential bicameral. So that is what we have in 1973 Constitution, a Congress made up of two houses, the House of Senate and the House of Representatives. They tried to make corrections in the various provisions of the Constitution correcting it from parliamentary to bicameral presidential. But they missed some provisions. And one of the provision they miss is the provision on how Congress shall vote for the purpose of convening as a constituent assembly. They forgot this. And that is where the problem lies. My take is that without the enabling law, the initiative, people initiative, cannot be exercised. In other words, all clamor for people's initiative is premature. What I suspect, the real purpose of those who are pushing for people's initiative in order to include in the provision the word voting jointly, the real purpose is to raise the issue before the Supreme Court again, so that the Supreme Court will have the chance to reverse Santiago and declare that 6735 is adequate and in that one thing. Now, once they do that, if they can convince the Supreme Court, then the initiative can henceforth be exercised. Until then, there's nothing to conduct. There's nothing to conduct because there is no mechanism of people's initiative as of yet. Now, let me end this talk by emphasizing that the Constitution is our social contract. Kontrata po natin ito. Ito'y kontrata ng sambayanang Pilipino, defining the organization of government, defining the power of government, and defining the limits of the power of government, as well as recognizing the individual rights of every person, defining the zone of freedom into which government is prohibited from intruding. That is how important a constitution is to us, because this is our agreement. And we are the sovereign Filipino people. You are the sovereign Filipino people. As I can remember, during the inauguration of President Noynoy, the late Noynoy Aquino, at Luneta, Sal Park, he was delivering his inaugural speech. Thousands of people were there. Then at one instant, he stopped, he looked around, then he said, "Kayo ang boss ko." Thank you, Lord. You are my boss.